Sorry, everyone, for switching this to virtual only, but I don't know about the rest of you. I still have 6 inches of snow and ice all around me. Whoever mentioned they were from Alaska probably is not impressed by our 6 inches of snow and ice, but for Seattle, it's going to shut down the whole region. And in fact, my kids had no school today. Unfortunately, Aaron, we're unable to deliver pizza directly to your house, but if you enter your personal information and credit card into the chat, I'm sure I can get that taken care of for you.
Alaska commiserates with your 6 inches of snow. We have an inch here, and it's already getting to be too much for for me to get up my driveway in all weather tires.
Wow, that's I would assume that you're used to a lot more snow on a regular basis.
I mean, it's always the first time. every inch is always the first inch. And my family lived in North Dakota when I was a kid for a little while. So you'd think between that, I would have.
Think you'd got it, yeah.
Nope. So you got my sympathy.
Can anybody see me yet? No, of course not.
Not yet, but we can hear you.
Well, that's a good first start because I've been sitting here trying to get this thing started. Open system preferences. I'll zoom to look at my camera. Oh, come on, camera. Zoom.
Stephen, was that you?
That was probably me. Who knows? Quit and reopen.
While Jean is fiddling, I think she quit and read. She'll be back. Just a quick announcement. We are planning on booking out the Mercer Island Community Center for as much of 2023 as we can. We will continue to have a hybrid event. As a matter of fact, we will be stepping up our game, bringing some better audio-visual equipment to the community center in the future. We were going to try to do that today, but clearly it's not necessary. So,
yes, we do need to step up our game as far as getting a bit more literal light on the subject here. Unfortunately, I was stuck on a different computer than I normally use, but I think Jake has been doing a great job of introducing himself.
I haven't actually introduced myself. I've been stalling for time.
You've done a great job.
All right. I guess so. I'm going to share my screen. I guess, Jean, do we have any chapter announcements? Like half the board is either out of the country or traveling, and I just want to make sure before we get into the program that we have covered everything.
Yeah, I mean, we normally talk a little bit about the mission of IC² and the board, but I think at this point most people know who's on the board or don't really care at the moment.
Well, we do have some changes.
Yeah,
since I believe last time.
Jake has taken over the role of secretary on the board, and Agnes Goss has taken over communications. One of the things that we are really interested in is getting additional chapter members to participate on our board. So if you're interested in working on the board, please contact myself, Frank, or anybody else on the board. The City of Mercer Island has been really good to us and allowing us to reschedule. So they are shutting down the Mercer Island Community Center until the 3rd of January. So we may have to change the actual date that we would normally meet. But that's to be decided by the City of Mercer Island, and we'll work that out. The other thing that I wanted to do, of course, was to announce that Jake is going to give this talk on proliferation of privacy laws. There are so many new laws coming. It's really important to pay attention to this.
And just looking at the calendar, it would seem that fortunately for us, January 5th would be our first meeting. So hopefully they'll reopen by then and we can use the community center.
I would hope so. What else is going on? There has been some changes in IC Square, they have a new board, and the IC Square International. If you're interested, go to their website.
They also have they're talking about proliferation of ISC squared certifications.
Yes.
I've just noticed more and more are coming into existence. It's no longer just CISSP and I think a handful of others. So, I think what's I most want to kind of point out is I think they call it certified in cybersecurity. Isn't that
Yes.
the kind of entry level?
It's the entry. Yes.
Yeah. So that's new. I want to say it's very new, like within the last 4 or 5 months, if not even newer than that.
And they've been offering a discount on the membership for people who are interested in joining IC Squared who haven't already joined. So you might want to pay attention to that if you're interested in that. We will also be working with the ISSA chapter to present a CISSP course starting in March, I think. Probably in person. So if you're interested, it's for a very minor fee, like it hasn't been set yet, but in the past it's been like $200, $250 or something like that.
It's a lot cheaper than the courses that you will find elsewhere.
Absolutely, and we are the people with the experience who've been through this already, so we have a lot of insight into the craziness that goes around a lot of the certification testing. So with that being said, those of you who don't know Jake should know Jake. He's an amazing person. He's a partner at LC Gates. He's on our board. He has both a CISSP and a certification in privacy from the IAPP.
Oh yeah, I do now. Forgot about that.
You do. And he's very, very passionate about privacy laws and cybersecurity. And, he's one of my favorite people.
Well, thanks, Gene. And I'll just say, for those that don't know, I'm a partner at a law firm, so I'm a practicing attorney. I do 95% of my practice these days is in cybersecurity and privacy. So this presentation was adapted from an adaptation of a presentation I did at Secure World just last month. So if you happen to be there, that this will be there will not be very many surprises. But if not, I think you will find this really eye-opening and perhaps a little scary. So yeah, the title is it's about as accurate as I can make it. There's a lot of privacy laws coming into play, and they really are going to play a role in for cybersecurity professionals. And there's a lot of reasons for that. One is that and this is an argument I had internally when I first joined, privacy in the legal sense tends to be a stand-in for cybersecurity as well. Cybersecurity as a separate concept obviously is very large and very important, largely within the cybersecurity industry. If you just say privacy to the average business person or lawyer, they're not going to know that there's a difference. So obviously there is a difference. But what's super interesting about most of these laws is that they get lumped together. And so a lot of privacy laws also turn out to be cybersecurity laws. So in terms of what I want to talk about today, this is generally 45, 50 minutes or so. And I'll kind of leave time for questions. I think at the end, given the Zoom format here, rather than try to take them as we go. I also can't see the chat for some reason. So if you chat at me, I will see it after I turn off the presentation.
Or I can just...
Or Gene, yeah, if you want to keep an eye on it, let me know. That works too.
I will do that.
Okay, that's great. Okay, so feel free to send a chat, and if Jean feels it is appropriate, she will interrupt and pass along that question. So this is mostly U.S. focused, though there are some kind of global things I will touch on. I do want to spent a little bit of time talking about what is actually going on in the enforcement world and some case studies. And then we have some kind of litigation-y, liability-focused updates at the very end. So without further ado, here we have trends in US state legislation. So state legislation is a constant push and pull between what I will just call, without making any judgments whatsoever, the business community and the advocate community. The business community wants to, in general, again, no judgment, minimize or decrease the regulatory burden of businesses, whereas the advocate side doesn't really care about the regulatory burden. They just want to have the most robust privacy rights for individual consumers. So what this ends up creating is, and this is really no surprise, is that you tend to see blue states have a little bit more pro-consumer, pro-privacy, and then red states may be a little bit pro-business. And that is, out of our total sample size of 5 currently, that has been true. That last paragraph kind of shows, California has the oldest one at this point. CCPA was passed in 2018, took effect in 2020, and then in 2020, the California Privacy Rights Act was passed, and that will be taking effect, as you will soon learn, in a few weeks. But it continues to be the strongest, most consumer-friendly privacy law. Connecticut and Colorado, they lean consumer. I don't want to say they're not as heavily consumer-leaning as California, but definitely more so than, for example, Utah, which really goes the other direction. It is the most business-friendly. And then Virginia falls somewhere in the middle, which I think probably goes along well with the various colors of these states as we talk about. The biggest fight, almost inevitably in all states, is over this private right of action. Many of you are in Washington. You may be wondering, well, we're kind of a blue state. Why don't we have a law? And this is why. The fight here has been, how strong should the private right of action be? In many states, it's whether there should even be a private right of action. And for whatever reason, it's been 4.5 years, and the legislature here in Washington cannot get the votes to progress what has been called the Washington Privacy Act. So we will see where that goes coming into a new legislative session. Obviously, industry prefers what I just call attorney general enforcement, which means no private right of action. And that means, for all the non-lawyers, which is almost all of you, that you can't sue as an individual. And what it really means is that there won't be class action lawsuits. So think of it this way: private right of action, if that is yes, then there's the possibility of class actions. If there is no private right of action, then it's probably going to be government regulators only. And then last, just wanted to point out that most of these laws, actually all of these laws, have exemptions for a few of the sectors of the economy that are already regulated with respect to privacy and security. Examples being HIPAA, and then so for obviously healthcare, and then Gramm-Leach-Bliley, which covers financial institutions. Here is a handy chart of where things stand as of right now. California, this is the new CPRA, the California Privacy Rights Act. It will take effect January 1st, as does the Virginia Consumer Data Protection Act, or Data Privacy Act. And then Connecticut and Colorado follow in July, with Utah exactly 1 year away. Look at that. And what you notice across the board here is a lot of similarities, even between Utah and Connecticut or Colorado. There's some similarities. The challenge, though, is really that scope, the second row. And California stands alone here as having a gross revenue threshold. I call it an applicability threshold, and that is 25 million. If an organization, and that's defined pretty broadly, it's, you can just think of it as the whole company, no matter how many different corporations it's split up in, or even how many different countries it spans. But if you make more than 25 million, then the California Privacy Rights Act applies to you. If you make less than that, but you happen to deal in personal data and have either 100,000 or more consumers or households, or derive 50% or more of your annual revenue from selling that information, then the CPRA will also apply to you, even if you don't have 25 million in revenue. For the rest of these states, though, it's really much more limited to, I tend to say, the 100,000 consumer limit. And in those instances, that is 100,000 in each state. So in order for Colorado to apply to your company, you need to have the personal data of 100,000 Colorado residents. Same goes for Virginia, Connecticut, et cetera. So the rights of the data subject, again, this is where they're most similar. People have heard of the right to be forgotten. That's pretty much considered the right to deletion in the US. Right to be forgotten was kind of GDPR language. And what you see is, in general, there's a right to access, which means I get to know what information you have about me. There's a right to correct that. So, you know, if I exercise my right to access and I discover that you've got things wrong about me, I have the right to ask you to fix it. The right to deletion for sure. And then it gets a little bit more state specific. Some have this right to data portability. Some have a right to opt out of targeted advertising. And then even some have, over in California, there's rights to limit the use and disclosure of sensitive personal information, which is unique from, you know, simply opting out of the sale or sharing of data. So not intended to be, you know, going into major detail about what all of this means, but what to think about for all of you is almost all of these, almost everything on this page is going to impact you in some way or another. Either you need to be able to authenticate people who want to access or correct or delete their information, since it's all going to, most of it, not all, is digital, then that's going to kind of, you know, affect the IT systems and just the overall security of the company. So I think I will take one moment and just ask if there are any burning questions about kind of the general high-level kind of overview that I've provided about US state privacy laws and the way things are going.
What is reasonable security?
Next question.
So it's a tough one.
Yeah, it's a really tough one. In fact, I was just kind of complaining about that with mine and many of yours, friend Kip Boyle, that, you know, we've seen a shift in the FTC settlements, largely because they were forced, and I will kind of get into that. So I might actually save the answer to that question for a little bit later, but I will say that it's complicated and it is not very well defined. And I'm kind of thinking that everyone here would prefer a lot more kind of prescriptive as opposed to what we have right now, which is do something and make it good. It's very challenging to figure it out right now. Okay.
Robert had put out a question, which I think we've talked about. Is there any real effort to have a uniform U.S. law instead of state-to-state regulation? I think you were going to talk about that.
Yeah, so I'm going to get to that. That's going to be a portion of this for sure. And I think the news there is mixed. Okay. So real fast, I'm just going to go back in time a little bit further to 2021, which is still last year. What you had a couple of interesting things going on in the healthcare space. The Congress passed this, I call it not quite a safe harbor, but basically the enforcer of kind of the HIPAA high-tech, data breach and all of those rules is the Office of Civil Rights within the Department of Health and Human Services. And what they said is, okay, if you follow, quote, recognized security practices, and then they define that, we're going to give you the benefit of the doubt. And if that sounds squishy, it's because it is. It's like I said, it's not quite a safe harbor, but it definitely has value. And what's really interesting about this is what recognized security practices means. And the way it's defined in the statute is essentially anything that CISA or NIST publishes or says about cybersecurity and privacy. So that's good news because it at least helps companies that comply with HIPAA to understand with a little bit more specificity what they should be doing rather than just kind of this reasonable question. Okay, other privacy laws that were adopted in 2021, Brazil, South Africa, China, and then obviously the US with Colorado, Virginia, and California again. I'm not going to really talk about that. Brazil and China both are still trying to figure out what they're going to do. The regulations have been a long time coming. China is an interesting case. The temptation might be to say, well, that's ridiculous. Everyone knows there is no privacy in China. With respect to the government, that is correct. The state, the privacy law in China called the Personal Information Protection Law, I believe. I just call it PIPL. It obviously does not provide you any privacy with respect to the government. However, with respect to China's private sector, such as it is, and the rest of the world's private sector, it actually is a fairly robust law, and there is no official English translation at this point. But what I have read about it really does indicate that at least in some ways it is fairly robust. We're coming up on a deadline with respect to GDPR. Early last year in 2021, there was a publication by the European Union Data Protection Board providing new standard contractual clauses. These are what you have to use in order to transfer data outside of Europe. You can think of it as the replacement, or currently it's the only way to do a cross-border data transfer now that Privacy Shield is invalid. However, there is hope on that front, which I will talk about in the next slide. Just FYI, this December 27th, 2022 deadline is for adopting the new standard contractual clauses with existing contracts. So if there's only 26 days left, hopefully that's been taken care of by now. If you're not sure, you should ask your privacy personnel or in-house counsel, and maybe they'll be able to tell you. Next, we have the White House executive order from May of 2021. This one was really about getting the federal agencies to take cybersecurity to the next level, and that has had some good effects. And then last but not least, we have the FTC's rulemaking under Gramm-Leach-Bliley. The safeguards rule for financial institutions was substantially updated. It really does add quite a bit of what I'll just call cyber risk management. This says effective December 9th, 2022. That is still true for some parts, but the most challenging, and I would say useful parts, have actually been extended into July 2023. So there's a bit of time left to become compliant with those. If you, chances are, if you're subject to GLBA, you already know. But if not, again, that's a good question to ask in-house counsel. Okay, notable regulatory actions. So much has happened. This is just this year. So first, my favorite agency, which of course is NIST, was quite busy. They published this update to special publication, that's what SP stands for, 800-161, titled Cybersecurity Supply Chain Risk Management Practices for Systems and Organizations. That was in response to the executive order, but it also is just very helpful given how many supply chain impacts we have seen over the last few years during the COVID era related to cybersecurity failures. Kaseya, obviously SolarWinds, et cetera, et cetera. They also published a report on ransomware risk management. I love that they translated the cybersecurity framework into 7 additional languages. It might even be 8 now. And then they just updated like crazy many other cybersecurity resources that are in existence. I think it's very useful. It's a great tool. I assume that most people in cybersecurity are at least passingly familiar with NIST and what they do. If not, definitely worth checking out. An agency you're probably not as familiar with, at least not intimately, is the SEC. They can regulate. Well, they have almost total regulatory authority over investment advisors and investment companies. And what they did in February was publish a proposed rule, and this is the full title: Cybersecurity Risk Management. And guess what it does? It would require these companies to engage in regular and, I don't want to say overly prescriptive cyber risk management. I think it's actually not that bad, but it would be a big change because right now the rules are incredibly vague and arguably don't even exist. But then they outdid themselves the following month with kind of this cybersecurity risk management strategy, governance, and incident disclosure proposed rule. And again, these are both proposed. Don't know what's going to happen with them. The March one would apply to all public companies and would really shine a light on a number of cybersecurity practices, in particular, cybersecurity expertise or the lack thereof on corporate boards. So I think that would be a really big shift if that rule was finalized, but right now I just don't know if it's going to be. Okay, so we also have some, I guess I'll just hit all the FTC ones at once. So easily winning the contest for my favorite name of a remedy is the case involving Kerbo and WW International, the company formerly known as Weight Watchers. And what happened here is that Kerbo was an application targeted to kids, and Weight Watchers used it to gather information from those kids in not in compliance with the Children's Online Privacy Protection Act. The result was something called algorithmic disgorgement. You could also call it a AI lobotomy. It's also would not be unfair in this case. What the FTC did was they said, okay, it's just not enough to fine you because you're still going to have kind of your ill-gotten gains, and you'll be able to generate new money based off whatever it was that you learned and the data that you had. So to prevent that, they required algorithmic disgorgement, which in this case meant deleting all the data used to train the machine learning algorithm that they were spending all that time and money on. So I think this is probably one of the most important things that happened in 2022. As AI and machine learning algorithms, expand in scope and just proliferate in general, this type of thing is a huge business risk. Essentially all of the effort and development time that went into developing that algorithm and training it was undone because essentially they didn't get consent properly under COPPA. So that's a big deal. And just to be clear, algorithmic disgorgement is not limited to COPPA, the Children's Online Privacy Protection Act. That's just the statute that Kerbo was accused of violating under that in that instance. So really, anytime the FTC can sink its claws into your company, this now becomes a potential form of remedy. Just for fun, okay, let's see. Skip down to Lena Khan. She has now been chair for a good chunk of the year, and they've just been very busy. In April, she announced that the FTC was considering rulemaking to address privacy and cybersecurity deficiencies. Later in August, they actually issued a document that they were going to be exploring official rulemaking. They called this commercial surveillance and lax data security practices. So you can kind of tell what the FTC thinks of the general state of cybersecurity in the private sector. In short, they're not particularly happy with it. Let's see. Also on this slide, obviously at this point, the Russian invasion of Ukraine is old news. But keep in mind that when this first started, we did get actual specific warnings from the Cybersecurity and Infrastructure Security Agency, CISA, warning us of Russian cyber attacks. So it hasn't really stopped, of course, but that is a thing that's an agency action that was interesting. This US-EU framework for transatlantic data flows, which inevitably will be called Privacy Shield 2.0, it was proposed back in March, and let's see if it's on this one. Yes, the executive order was signed in October to kind of move ahead with Privacy Shield 2.0. So it's not done yet. I don't know that it will survive scrutiny of the European Court of Justice or the Data Protection Board, but it is at least something. So there is some effort to kind of revive Privacy Shield. Other things of note on this is in September, the FTC continued to stay busy, and this time they held a public forum regarding commercial surveillance and data security. I'm not going to bore everyone with the details of Magnus and Moss rulemaking, but suffice to say, it is a very long and painful process. Some estimates would say up to 6 years of rulemaking before anything will happen. That's why the FTC doesn't like to make rules using this process. It's just too slow. It may not matter if we get a national law, but I think at the same time, the FTC is kind of tired of waiting, and they have the authority to do this. So we'll see if that goes anywhere. Speaking of authority that is not in question, you have the first ever CCPA settlement with the California Attorney General happening just in August of this year. It was a $1.2 million settlement, which, not that much. There was injunctive relief, which basically, restricts Sephora's opportunities and behavior in the future. I think what's interesting about this case, though, is what it was about. And if you've heard of of GPC, or General Privacy Control, it's a browser. It's an attempt at a browser-based standard to declare one's intent to not be tracked online. It is different than do not track, just to be clear. GPC is kind of more specific to CCPA and other opt-out regimes. And basically, Sephora's website didn't respect the GPC. So what was supposed to happen is if you are a person with GPC activated and you visit Sephora's site, Sephora was supposed to note that GPC was in place and opt you out of the sale or sharing of your personal information under the California Consumer Privacy Act. Since it's not even really clear what opting out means, which is a totally separate issue, should not be a great surprise that Sephora didn't do it. Nonetheless, the AG went ahead anyway with this settlement. So I don't know what else to say about that other than it was a big deal amongst marketers, because that's generally what this is about, is marketing. I think it remains to be seen what happens with the successor to the AG as the California Privacy Protection Agency takes over. And yes, you are seeing this correctly. We have CCPA, CPPA, CPRA, and then don't get me started on Colorado and Connecticut, who also have privacy acts. There's a whole lot of C's and a lot of P's and a lot of A's, and it just gets very confusing very quickly. Suffice to say that the California Privacy Protection Agency is the United States' first dedicated privacy protection agency. This is all they do. They basically get to start up in a month on January 1st, and then probably they won't be able to begin fully enforcing the regulations until those are finalized. So I would expect sometime in July for things to get really interesting for any company subject to California Privacy Rights Act. And then last but not least is the FTC did hold its 7th annual PrivacyCon on November 1st. Okay, legislative updates. So not to get into crazy detail about the difference between legislatures and federal or state agencies, but essentially agencies can, they do a lot of this under the executive branch, whereas obviously legislatures make actual law. So what law was created and passed? As mentioned, Utah and Connecticut, they both passed, they'll be taking effect. Laws were proposed in Arizona, Florida, Iowa, Louisiana, Washington, Wisconsin, and I believe others as well. I think there's a map in here that I'll show you a bit later. And these are just comprehensive privacy laws. So think of these as mini GDPRs or mini CC, or not necessarily mini, or CCPA clones. Sorry, I'm going to take a second. If anyone has a question, now is a good time to ask while I take a sip. Numerous adjustments were made to kind of what I call assorted privacy and cybersecurity related laws. These are things like data breach notification laws, right? It's not a comprehensive privacy law, but it still deals with privacy and cybersecurity. Australia is a fun one because things have been happening really fast. Over the last month, I want to say, we have seen massive data breaches down under. And in response to that, I want to say within the last couple of days even, Australia has passed some new laws, and I don't even have details on those. I just know that it happened because I saw the headline. So that's much is changing down there. A U.S. law that kind of snuck by a lot of folks because it was hiding in an omnibus, I think, just government funding bill, was this CIRCIA, Cyber Incident Reporting for Critical Infrastructure Act of 2022. You've got time. The initial rules that are going to implement it don't even need to be published until March 2024, and then I believe another year or two before they can take effect. However, it is worth noting that the definition of critical infrastructure is incredibly broad. It's much broader than you would think. It's obviously power generation, water treatment, but it's also commerce, credit cards, finance, manufacturing. Basically, if you were able to take advantage of being a critical industry during COVID, then this law will probably apply to you. So talk about plus minus. And then also passed in California was something called the California Age Appropriate Design Code Act, which some people are calling CAADCA, just because we don't have enough C's and A's. It was passed last September. It's an effective date of July 1st, 2024. Basically, if you're making an application that deals with children, then you've got a whole lot to do and to look forward to in terms of dealing with that. The intent is probably reasonably good, which is to stop companies from manipulating children through clever mechanisms. How that's going to actually play out, nobody knows. So we'll see. Okay, and Robert, finally answering your question, yes, there has been a real effort. In fact, it's been the most significant effort in 20 years. It's the American Data Privacy and Protection Act. A discussion draft was released by its committee in the House on June 3rd. Many different articles, news outlets, and the Senate and House itself called it the first bipartisan, bicameral, and comprehensive privacy bill in 20 years. I don't want to get anyone too excited about it because it didn't pass. But at the same time, the reason it didn't pass is primarily fights over preemption. California's delegation in particular, including Speaker Pelosi, didn't want California's various privacy laws to be preempted, which means overridden, basically. And I suppose I can understand why, but from the perspective of the rest of the country, the whole point of a national law is to simplify and bring it all under one comprehensive set of regulations and rules. However, with the Republicans taking back control of the House and Speaker Pelosi, I'm trying to figure out what you mean there, Gene, in your private message. So maybe we can you can just ask and we can talk about it.
You finish your thought and I'll ask my question.
Okay. So and the end of the thought is that I don't count the ADPPA out quite yet. There's certainly a chance it could get resurrected and passed next year. Okay, what's your question?
A number of these laws, of course, are very, very similar, and you can respond to them in similar ways. But at some point, you're going to have laws that step all over each other, which they do today anyway, with the various states. Which one will take precedence?
So that's what I was actually just talking about with the preemption. There's a federal law can preempt state law. Okay. In fact, let me just hit this button. So if the ADPPA were to pass, then it would basically wipe out all of the state laws that do the same thing. And then you don't have this question of what takes precedence. You know that it's the ADPPA that takes precedence. This is how kind of CAN spam works. Right. It preempts state laws. And the reason for that, of course, was that it just wasn't going to be workable for there to be 50 different, anti-spam laws out there to comply with. That's just not how the internet functions. And
the reason I ask is because you'd have a couple of states that have similar but competing laws. And then you have companies, of course, that work right across the US and Canada and all over the world.
Yeah.
And they don't know which ones necessarily would be. Is it the state you're located in? Is it the state your customers in? What takes place?
So in general, the state laws are only going to apply with respect to citizens of that state. I don't know if that helps. But an example is, Utah and California. They're not opposites of each other. Like I wouldn't necessarily say they're totally at loggerheads, but to the extent there are conflicts, Utah's law is going to apply in Utah, and California's law is going to apply in California. The problem, if you want to call it that, with California in general, is that it's so big. It's like, what is it, the 5th largest economy if it was its own country? And so you just can't avoid California, right? Like if Utah or Rhode Island, passed the world's most ridiculous privacy law, there's a lot of businesses that would just say, fine, we're just not going to offer our product, or we're just not going to do business in that state. You can't do that to California, right? So, well, I suppose you could. It would be very brave. But in general, that's very difficult to do. Chris, you've used the hand raising function, so I'll go ahead and call upon you.
Yeah, thanks. So just a quick question when it comes to the applicability, just kind of piggybacking off the last question. So, this was a particular interest to me because right now, the company that I'm currently with, we're in kind of a phase where a third party is doing a due diligence with our processes and security practices. And we're in property management, and so it's very geographically specific, I guess. And we do manage properties in multiple states. So during the due diligence process, they referenced particularly the Virginia and California acts. And so we are obviously pressing forward, with the intent to be compliant under both of these. But I guess, and I'm a cybersecurity student and kind of an intern right now, so obviously I'm not a seasoned professional. But I guess my question is similar to the last one of, how far do these acts apply? And my boss, who's the head of security, the example they used was, well, if a California resident applies to be a resident in one of our rental properties in another state that's not Virginia or that's not California, are we required to be compliant under the California law if the property that they're applying for is in another state without a Privacy Act?
So that's a specific and interesting question. I would say that in general, these laws follow the person in that, and the rights that a person has, it really depends on where they are. So, with property management, it's interesting because you can't really, it's very, 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 as your example shows, it's very, very geographical. You almost cannot, a lot of the time it solves itself, right? Like if the California person moves to Oregon to rent there, they're no longer a California person, so the California law doesn't apply. But I think your question is a little bit more nuanced than that, which is, and the answer is, if they stay in California and you have their personal information, then you have to comply with CCPA/CPRA.
Got it. So, I mean, really, by using our online tool or our website, we are collecting some information on them regardless. And so, being compliant with California laws keeps us in the green zone, I guess, for, if they do in fact not rent, they're still, we're still liable to protect their privacy under California law.
Pretty much, yeah. I mean, that's the issue with the CCPA that people have dealt with, the last several years, is that it's so pervasive. And if you have any kind of truly online business, you're just not avoiding California. I've had people ask me, if we geolocate and block IPs from California, do we have to comply? And the answer is probably no if you do that, but then you don't have access to California. So,
and you do have a number of people who are temporary residents of various places. I mean, you have snowbirds, you have people who do consulting work.
Yep. And that creates even more confusion. I mean, even with the GDPR, it technically doesn't say citizen; it just says people in the union. So, you could, in theory, we could all take vacations to Europe and try to exercise GDPR rights when we're over there. Of course, we lose them when we come home, which is a little odd. But yeah, and keep in mind, this whole area of law is not exactly old, right? I mean, it's the GDPR has only been in effect since May 25th, 2018. So there's a lot to figure out still. Here's that map I promised. So obviously it's showing the 5 green states where something has been passed. Notice all of the dark gray though, those, or even, dark gray. My guess is that, which is half the country, that, to me, that indicates that any of those could become active as soon as the legislature goes back into session. So, this was updated October 7th. Most legislatures have been out of session by that time. That's why you see a bunch of inactive bills. But I really think we're going to see a lot more pushes next year on this. Here's just a quick kind of look at privacy law comparison with GDPR as the baseline. I think for what it's worth, just realize that many countries are following suit with this. Big, small, doesn't matter. Whether they have effective enforcement is a totally separate question, but laws are being put on the books. That's what's happening. So let's actually talk a little bit about the enforcement actions and what's going on. I've already mentioned how the California AG was responsible for enforcing the CCPA. That switches over to the CPPA when the CPRA takes effect. The single biggest change under California Privacy Rights Act is that there had been so-called B2B and employment exceptions under CCPA. Basically what that meant was that if you collected personal information that was either solely between businesses or for any kind of employment relationship, that CCPA didn't apply. That exception is being phased out in a month. That will be gone, along with the 30-day cure period that used to exist. That's also gone. In terms of lessons from CCPA enforcement, I did talk about Sephora here. I think the interesting thing about this was that it was just an enforcement sweep of online retailers. And I don't think I mentioned it. I'm a former assistant attorney general for Washington State. My first 7 years of practice were in consumer protection, effectively having the same authority as the FTC, just limited to Washington. And the concept of these sweeps is not new. I was part of several of those. Basically all it means is one or more states decides that they're going to focus enforcement on a given industry, and they just start looking. So that's what happened with Sephora here. I do expect more aggressive enforcement of the CPRA. What about GDPR? People often ask this. I probably could have updated this. I let it go. But as of November 17th, so first of all, down here, this little credit, let's see, how can I show you? There we go. Down here, enforcement tracker. It's a great website, super interesting, lots of data. What it does is it keeps track of all the different fines and the amounts and the reasons for GDPR. And I've already done some of this for you. As of November 17th, there were 1,352 total enforcement actions, totaling 2.11 billion euros. If you look at a graph, you will see that it started off slow, but has really kind of, hockey sticked in a way. 4 of the 5 largest fines were issued in 2021. And you can notice that these are all large companies. This 405 million euro fine against Meta, that's relatively recent. That was this year. What do you learn from this that's interesting? Well, so obviously the vast majority of fines are low. You can just tell if you see that, if you just do the math on this page alone, you will quickly find that these, really it's, what is it, Amazon, Meta, and Google, and then Meta again, account for just more than half way more than half actually of all the total fines. But when you dig in, you find things that are bizarre, like someone complained about an HOA which was fined 900 euros for something. It's hard to say what it was. There was even an individual who was fined 300 euros under GDPR. To me, that's really interesting because that would never happen in the US. That no government agency is going to waste time on a $300 fine on a single person if there was even a law that would allow that. The fact that that does happen under GDPR should at least make you realize that nobody is too big or too small to be fined under GDPR. They do kind of break it down by violations. It's not particularly helpful. Like, for example, this 1.2 billion euros of fines, it was for the non-compliance with general data processing principles. Well, that's not very helpful. But nonetheless, some of this is more useful than others. Okay, FTC enforcement and guidance. We'll spend very little time on this. Yes, the FTC Act does not specifically regulate cybersecurity or privacy. The FTC, for the last several decades at this point, has been enforcing using the unfair, deceptive acts or practices portion of the statute. Essentially, courts have said, starting with Wyndham, that yes, it's unfair to have bad cybersecurity or to not protect people's data. That's grossly oversimplified, but that's how this is done. Now, this LabMD case, so I talked about Weight Watchers, obviously. The LabMD case is interesting, and this is why. So up until LabMD, which I want to say was 2018, give or take, what you saw when the FTC brought a case and settled was exactly what Gene asked about: reasonable security measures. Not just any, but to the extent that it helps, they have to be appropriate for an entity of similar size and sophistication, and you're supposed to take into account the type, amount, and methods of data collected. But if you're thinking to yourself, like, that doesn't really help me know what to do, you're not wrong, and at least one court agreed with you. LabMD basically fought back against the FTC, and what the result of that was, a court declared the reasonable security measures injunction to be too vague, literally too vague. And so now what you have is kind of this new, at a minimum, I don't want to call it a standard because it's not a standard. It's an at a minimum set of requirements for an information security program. In general, you'll find a whole lot of requirements for things like documentation, written evaluations, regular formal documented written assessments, and then testing and monitoring of all manner of of the company's controls, things like that. There's also a very Sarbanes-Oxley style certification requirement for senior leaders. For those who don't remember Sarbanes-Oxley, that was Enron. That was a response to Enron and the whole concept of failure to audit. So what you're seeing is, essentially the question is being asked: can we trust that companies are doing what they should be doing? The answer has been no in a lot of situations, and that's kind of government and lawmakers are struggling with what to do, how to fix it usefully. And this at a minimum concept is one of the ways that they have tried. Let's see, I'm going to skip this, but basically, even the FTC can come after you even if you bought and sold a company. The message here really is, if you're involved in an M&A transaction, do your due diligence. And if you're the buyer and you find something wrong, fix it. Because if you don't, the FTC might find out, or worse yet, you might get, something might happen which causes the FTC to check, and then you can get fined and put under one of these 20-year consent decrees. So that's always a bad day. Okay, wrapping up before my voice gives out. Other federal enforcement activity. I'm sure everyone in this group is quite familiar with the Uber CSO Joe Sullivan being found guilty of covering up the Uber data breach. This was it's exhausting to talk about. We talked a lot. It came up quite a bit at Secure World in some of the sessions, but basically, I think this is a fairly isolated incident related it's more about Joe and his past than it is any kind of large scale concern for CISOs or chief security officers in general. I think that it's difficult to know all the facts, obviously, having not been in the trial, but largely what the jury found was that Sullivan actively concealed information from the FTC. That's the obstruction of proceedings charge. And part of it was the bug bounty program, and just kind of the way that he hid the details. Again, very complex. Next month, when we have a chance to go to what's the name of the bar we go to, Gene? I'm blanking on it. Anyone? The Roanoke. When we go to the Roanoke, I'd be happy to talk with you about that with a beer in hand. But it is a mess. But I don't think it represents
Has he
the
been
future.
sentenced yet?
I don't believe so. I think we're still waiting. I think I would have seen that, and I don't recall. I have not seen it yet. But I would expect soon, probably. The only other thing here to talk about is the Drizzly CEO. This one's interesting because it shows how the FTC is really trying to target the executives. Understanding that cybersecurity is more of a top-down issue than other compliance problems. They're really into holding the executives responsible, and that's what you see with with him being named personally and the proposed order following him around regardless of what company he goes to. In and of itself, that's not that weird. I used to do that, and the simple reason is that people who are serial scammers, and that's who I dealt with, like one of their favorite tricks is to, okay, I'll close this company and I'll start another one. It's really quite simple to start companies. And obviously, you don't want someone who has been guilty of scamming people to just be able to get out of the injunction or the penalty just by starting a new company. So in a way, this isn't remarkable, but in a way it is, because it's so specific to data security requirements and what he didn't do. So and there's a lot of articles on that if you're curious and would like to read more. Okay, two more slides, which is good because my voice is failing. Liability from data breaches. Just know that this is not simple. State law differs between the so-called access versus the acquisition standard. In some states, merely having an unauthorized access event is enough to be considered a data breach. Whereas acquisition, of course, is some evidence that the data was actually taken. Quick plug for the Verizon data breach investigation report. Every year it's always a great source of information for the industry. One of the things that's kind of interesting about this year's report is that it shows the convergence of ransomware it proves that ransomware is really just a business model for bad guys as opposed to any kind of specific technical meaning. And what you see is how the confidentiality and availability affected attributes in that table have converged. And all that it shows is what we all kind of know, which is, it used to be that they were satisfied with encrypting your stuff. People started to wise up to that, make better backups. Bad guys are thinking, oh, this is not good. They're not going to pay the ransom if they have a good backup. So I'll tell you what, we're going to steal all the data first, then we'll encrypt it. And then even if our victim has a backup, we can still just blackmail them with release of the data and maybe get paid that way. So that's really all that's showing. Last but not least, until I open it for questions, is a couple of interesting things relating to war exclusions in insurance coverage. So I'm sure many of you remember the 2017 NotPetya attack. Truly a cyber weapon, if ever there was one. If I recall, it didn't even, yes, I jumped at that cough. I did hear that. It was not expected. but NotPetya was, I believe it was just a destructive malware. If anyone remembers exactly how it worked or what it did. But my recollection is that it didn't even bother with any kind of ransom. It just was like, encrypt, dead, no key, whatever. And it was just destructive. And I believe it's fairly well understood that it was a Russian attack on Ukraine back in 2017. And there was quite a bit of collateral damage. And what happened here was that I didn't write down the plaintiffs, but essentially a court held that the war exclusion in Zurich American's insurance policy didn't include cyber war. Well, I guarantee you that cyber war is being used now. Let's see, and then wire fraud. This is so-called silent cyber. It's effectively a thing of the past. You don't see insurance companies covering stuff that's not explicitly covered in the cyber realm anymore. They just lost too much money. So there you go. That was a lot of talking. Any questions? Feel free to unmute, turn on your camera, whatever. We're officially finished with the presentation.
So you have given us an incredible amount of
it's so much information
to comprehend, and yes, we are getting lost in acronym land, as I'm sure you are, with everything sounding so similar.
Yeah, and I mean, ultimately the point of this presentation was just to prove that, yeah, there is a lot of stuff happening in this space. It's probably the most active single area of law. I think of it's a lot like environmental law in the 80s and 90s. That really, for a while, it was like everyone wanted to be an environmental lawyer in some fashion or another. And there was, in fact, the insurance industry almost bankrupted itself under some of these environmental cleanup statutes. So if you want a metaphor or an analogy, that's probably the best one. But yeah, things are moving fast.
Something about Carlisle said.
Yeah, so Reuven Carlisle, I actually was just reading about that, that fact that he's gone, and I didn't even finish it. I'm literally talking like an hour ago. It's a good question. I'm sure somebody will. But I agree. Ultimately, I really would prefer to see the American Data Privacy and Protection Act go forward. I just think we need uniformity. We need clarity. It doesn't hurt that the ADPPA is actually a pretty good statute. So, yeah.
Do you think that it's best to, going forward, just assume that some of these more strict laws, the California Privacy Acts, the GDPR, or something you should, if you're going into new business, this is something you should just build into your
I think the irony of Pelosi's dislike of the ADPPA was that they think that the California law is better. I really don't think it is. I think it's actually weaker. I think if you're a consumer, the American the federal one is actually a better statute. It's more protective. But California has to be special. So they maybe they don't like it. Regardless, I do think that no matter what, there's going to be regulation. Hopefully it gets less confusing sooner than rather than later, but we don't know. I think it's the ADPPA would literally be an American GDPR, and I think that would be super helpful. Chris, you've got your hand up again. You can go ahead.
Yeah, sorry.
We can tell you're still a student.
Yeah, I know. Geez. So as a student, obviously, kind of the first couple of years has been a lot of tech.
You there?
Obviously, stuff like. Yeah, can you hear me?
Yeah, there was some static.
Oh, sorry about that. Yeah, so obviously, first 2 years are a little technical when you're going to school. A lot of network fundamentals and software fundamentals, that kind of thing. So now that I'm in the process of becoming familiar kind of in a short period of time with the compliance side of the house. It obviously kind of makes me go cross-eyed a little bit. So any good book recommendations? I did read Dawn of the Code Wars, which was written by, I believe, a former US attorney. So I kind of got to see a little bit of the law point of view of cybersecurity, but any other good book recommendations?
That's a good question. And unfortunately, I came at it from the opposite direction. So I was looking for technical perspective as opposed to the legal one. I mean, I usually tell my lawyer colleagues to read something like, what is it? Secrets and Lies by
Brian Krebs.
Yeah, no, not Brian Krebs.
Or Bruce Schneider.
Bruce Schneider, yeah. But that's not what you're asking about.
The Solarium, the U.S. Cyberspace Solarium Commission report is a really good student, non-legal, from my perspective, but I've got 20 years with the feds. I'm not with them now. Anyone who has not read that U.S. Cyberspace Solarium Commission report, I recommend it. I think I ended up with a dog-eared copy. I got a lot out of it.
So that's a good recommendation. Honestly, the CISSP Common Body of Knowledge, the section on the law is actually really quite good. So is the IAPP stuff for privacy. That's useful as well.
Awesome. Thanks for the recommendation, guys. I appreciate it.
All right. Well, a little bit longer than, well, actually, no, that's about right.
Well, so, Jake, we really appreciate you sharing your wisdom and insight. I mean, this is a lot to swallow for a lot of us. And you've done a terrific job in trying to get us ready.
Yeah, no problem. I'm sure I probably will be able to give this talk every year with totally new material, given the way things are going. So, okay. All right.
All right.
Well, thanks, everyone.
Also mention that next month, Brian Hurd will be talking about Could There Be Dragons, cybersecurity, navigating the cybersecurity landscape. As you probably know, Brian has a lot of hands-on experience with Aon, which is one of the major cyber insurance companies. And they also, I think, have a large law segment too, but Brian's a really interesting speaker.